All right, I'll see you all for jury trial tomorrow at 9:30.
You had said if we had any pre-trial motions to bring those up.
Yes.
All right, Judge. So I had filed a motion.
Kicking off strong, the defense wants to shut down YouTube broadcast of the trial. Why they argue it risks the defendant's right to a fair trial, but is that a legitimate concern or just courtroom theatrics?
Back in August, motion to prohibit the YouTube broadcast of all the legal proceedings.
And I don't have that motion. It's not in the court's file. We're going to have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Dillon.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Diller's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes, Judge.
Now, here's the twist. In a previous case, a key witness actually watched another person's testimony on YouTube. That's the defense's nightmare scenario, and it could absolutely derail a fair trial.
Okay.
But just for example, that was a main witness, and she admitted to watching YouTube. I'm concerned about witnesses watching YouTube. I'm concerned with potential jurors watching YouTube or asking friends or family to watch it for them. And so I'm just really concerned that Mr. Diller won't get a fair trial with this being broadcast all over the internet.
All right.
Now,
and would you want the media excused as well?
Usually the media doesn't video record.
Yes, they do.
Out of when the jury's out of the courtroom. Like for instance, like if there's a motion in limine and we're arguing about prior criminal record or something, the court grants it. I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay.
I don't have it to that. It's just broadcasting everything that happens in the case.
All right.
The reasons that, and I will, in the motion on page 2, paragraph 5, I want to waive that paragraph because I do believe the court has changed the YouTube channel and does not allow chatting any further. And so I will waive that. I'm also concerned that there's an alleged victim who is a minor, and under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy.
Things escalate. The alleged victim in this case is a minor, according to Texas law. That means added privacy protections. Broadcasting could risk exposing sensitive information should courtrooms pull the plug in cases like this.
And that by broadcasting it, her name will be revealed. And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
All right. Is there anything else with regards to your motion, counsel?
Well, the main focus is the concern for Mr. Diller getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that are watched by potential jurors and potential witnesses.
Okay.
And that's just too huge a risk.
All right. And this is your only pretrial motion?
No.
Just like that the judge denies a motion, the live stream stays the defense raised major concerns, but the court isn't convinced now the case plays out in front of the internet and the pressure is on all.
It's denied. What's your next motion?
I haven't filed it yet. It's ready to be filed. I can hand file it. Before I file it, I would respectfully ask the court to recuse
Okay,
on this case.
sure. We'll have a hearing on that,
Okay.
and that will be heard by Judge Hall. Ms. Ferguson, if you could call Judge Hall to see if he can have that heard immediately. All right.
Okay. And then the motion was a motion to recuse.
Okay.
The defense just pulled a bold move. They want the judge off the case. A recusal motion means they believe the judge can't be fair high drama, but high risk, because if it fails, the judge still presides now with.
Fine. Oh, counsel, you can file whatever motion you want to file.
Okay.
All right, and see if he can have that heard and let him know that this is scheduled for jury trial tomorrow. So perhaps if he can hear it in the morning, and that way we can move directly into jury trial. Is there any other motion?
Not for today, Judge. Like, we'll probably have a motion in limine whenever.
All right, you may want that heard because technically you have not filed the motion to recuse yet.
Right, you are right.
So,
You are right. Well, I can file it electronically when I get back to the office, or I can hand file it.
well, either you need to file it now. If you don't file it now, then we will hear other motions.
All right. Original 3 copies.
All right, and Ms. Ferguson, see if Judge Hall is available to hear that today, and we will be coming back here on the 17th for trial.
Oh, wait, today or tomorrow morning?
Now, see if we can hear it today or either early tomorrow morning.
Okay.
All right. Morning. So we're having a jury brought up. We'll see where we are.
Oh, okay.
Yes.
Do you expect that to happen this afternoon or?
Today. We shall
Okay.
see. All right.
Oh, okay. I thought there was a murder case.
Oh, there is, but you never know. Sometimes
Sure.
things fall through.
No, you're right.
All right. Okay. Thank you. All right. The court is in receipt for a motion for continuance from the defense. State, have you had a chance to review the motion for continuance? All right. Defense court will hear your motion.
Thank you, Your Honor. Well, I don't believe the state has an objection to it. And there's been some plea negotiations, but in reference to him being set for trial.
New play they're asking for a delay. The defendant's wife, a key witness, is out of town, and the defense wants to wait, but the judge is running a tight schedule delay, not looking likely.
Is the last time we were set at the week before the March 25th, we could have gone to trial then. I know you were in trial. And as soon as we got the new court date for
Just one
today,
second. Everyone in the box, please whisper. Yes, you may continue.
and so when I let Mr. Diller know, his wife chimed in immediately. I cannot be there the April 8th through the 10th. She'll be back from a conference that's mandatory for her employer, which is Southwest Research. She'll be back tomorrow, probably late in the afternoon. What's that? 8 p.m. tomorrow.
Okay.
But she's a crucial defense witness. In the motion, I outlined what I expect her testimony to be. I have interviewed her. And I have also attached an affidavit that details what her expected testimony is. She is a crucial witness for the defense.
All right. So here's my thing. You're saying she'll be back on tomorrow by 9 p.m.?
Yes, that's
All right.
expected.
So we would do jury selection. If your case is going, we'd do jury selection today. And I don't think the state is going to finish with their case, or they may be finished with their case in one day on Wednesday, but she probably will not need to be here till Thursday.
Then, then that would obviate. the
All right.
need
So
to do
there's
that.
no need for the motion for continuance?
Well, if the court is going to work around the schedule,
I mean, if you're telling me that she will be back on April 9th,
Be back the 10th.
the 10th. If she'll be back on the 10th by 9 p.m., if her testimony is needed, it will be needed at the earliest on the 11th. So there's no need for a motion for continuance? Is that correct?
Well, I mean, I'm not, I'm just saying she wasn't here yesterday, she can't be here today, and she won't be here till tomorrow night.
Well, it appears that her testimony is not going to be needed if you wish to call her until April 11th. So are you withdrawing your motion for continuance?
No, Judge, as I mentioned in the beginning, we have started talking about possible resolutions to the case. And broached this subject with him, but I really need her here to discuss things with her too, since they're married.
Well, I think you all better get on the phone, because if you still want to proceed on this motion for continuance for these reasons, the motion for continuance is denied. So y'all need to pick on the phone and call her if that's what you all want to do.
Okay. So then when would you want us back to start jury?
And if you want to speak to your wife, I suggest you all call her on the phone, because once this jury trial starts, it's starting. It's not stopping in the middle of trial because you all have worked something out. Is there anything else?
Not at this moment.
All right, thank you. The record for the state,
That done for the state, Your Honor.
defense.
Alex Sharf and Mr. Dillard, ready?
All right, and are you Mr. Diller?
Yes, Your Honor.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of injury to a child, bodily injury intentionally or knowingly? That's a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, Your
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of injury to a child. They're recommending deferred adjudication, and there's to be no contact with the complainant. Did you understand that
Yes,
to be
Your
the
Honor.
plea?
Yes, Your Honor.
Defense?
Yes, Judge.
Outside the agreement, the state is recommending that your community.
Here it is, a defendant pleads no contest to a lesser charge injury to a child. It's still a felony, but no trial, no jury. Is aiming for deferred adjudication, basically probation without a conviction, smart legal gamble, or escape plan.
Supervision be for a term of 5 years. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State offers states 1 and attachments.
Any objection?
No objection.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. The court has considered states exhibits 1 and attachments, which includes the stipulations. Is there any other evidence either side wish to present to the court before the court makes a ruling on sufficiency of the evidence?
Yes, Judge. Mr. Dillard would like to make a brief statement.
All right. Yes, Mr. Diller.
Yes, Your Honor. I grabbed her arm.
All right. And I'm assuming the grabbing of the arm caused pain. Is that correct?
Yes.
All right. Is that yes?
Yes, Your Honor.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this is a life-changing incident. Mr. Diller also suffered from a very debilitating accident in 2019. Prior to the outcry, before the charges were filed, he's in a great relationship, and he's been frozen in fear about fighting this case, and he would do it if he had to. His plea agreement, we believe, is in the interest of all the parties. Mr. Dellinger will not have contact with the complainant in the future.
Okay. Are you employed?
No, Your Honor.
So how do you support yourself? Are you on SSI or something?
I filed for I got denied for the original one because I have too many resources available to me because of my wife's income. Now they're doing the disability part of it, and I think they're at 95% right now.
All right. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with the complainant, proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Regular reporting.
Sentences in 6 years deferred adjudication, no contact with minors, anger management community service. And strict probation rules the court is giving him a shot, but one slip and it all comes crashing down.
By Zoom or in person. Regular random UAs. And due to your medical, are you on any type of medications?
Yes, Your Honor.
All right, you'll need to let probation know what those medications are, and you'll need to do a release from your doctor so they can make sure that those medications are being taken as prescribed. You understand? Bill visit 1 time per month for 3 months. 100 hours of community service restitution. If you would like, you can pay those off at $7.25 per hour. I always recommend the food bank because they always need help. But if there's another charity you would like to donate that to, just ask probation and they'll let you know if it's an approved charity.
Yes, Your Honor.
All right. Probation, and we'll do anger management. Probation, is there anything else? Is there anything else you need from the court to be successful? All right. I understand that you have some medical issues that may preclude you from employment. The court costs in this case is probably going to be around $385 to $400. So if there's a reason why you cannot pay that, just let probation know, and they'll have to do an indigency form for you to see if that's true and if it would be appropriate for that to be waived. Do you understand?
Yes, Your Honor.
Do you have any questions about anything?
No.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back.